Is the right to protest absolute, or can the government legally restrict it? Let us understand its constitutional basis, legal limits, important Supreme Court judgments, and international law framework. The Constitution of India does not separately use the expression right to protest. Instead, the right is mainly derived from two fundamental rights guaranteed under Article 19. Article 19, Clause 1, Subclause A gives citizens the right to freedom of speech and expression. Article 19, Clause 1, Subclause B gives citizens the right to assemble peacefully and without arms. A protest therefore combines two constitutional freedoms, the right to express an opinion and the right to gather peacefully. The freedom under Article 19 are specifically available to Indian citizens. But why does a constitutional democracy protect protest in the first place? Protests have played an important role in Indian history. During the freedom struggle, marches, public gatherings, boycotts, and satyagrahas were widely used against colonial rule. The Salt March led by Mahatma Gandhi is one of the best known examples. After independence, India witnessed movements such as the Chipko movement, protests related to reservations, anti-corruption campaigns, and the farmers' protest. A protest allows citizens to communicate demands, oppose a law, question an administrative decision, demand accountability, or draw attention to a social issue. The Supreme Court has repeatedly recognized peaceful dissent and public discussion as parts of democratic functioning. However, the existence of a fundamental right does not mean that it can be exercised without any limits. Article 19 allows the state to impose reasonable restrictions on fundamental rights. Freedom of speech and expression may be restricted under Article 19, Clause 2 on grounds such as the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, incitement to an offense. The right to peaceful assembly may be restricted under Article 19, Clause 3 in the interest of the sovereignty and integrity of India, public order. The expression reasonable restriction is important. A restriction must have a legal basis and must be connected to one of the grounds mentioned in the Constitution. Authorities may regulate the time, place, route, duration, and manner of a protest. They may also regulate participant numbers, loudspeakers, traffic arrangements, and access to security sensitive locations. So, what happens when these constitutional principles are applied to an actual rally or march? Peaceful rallies, marches, dharnas, symbolic demonstrations may receive constitutional protection. Violence, the carrying of weapons, assault, destruction of property, and incitement to an offense are not protected merely because they occur during a protest. Because roads and public places are shared spaces, organizers are commonly required to obtain police permission or a no objection certificate. An application generally mentions the purpose, venue, date, duration, expected attendance, and proposed route of the protest. Police may impose conditions relating to timings, traffic, loudspeakers, crowd management, and emergency access. Permission may also be refused or modified where there is a specific risk to public order, security, or safety. Permission for a stationary demonstration does not automatically include permission for a march. A gathering permitted at Jantar Mantar, for example, may require separate approval to proceed towards Parliament, which is a security sensitive area. The Supreme Court has supported limited and regulated use of protest spaces rather than either unrestricted occupation or a complete ban. For situations involving an immediate threat to public order, the law also gives authorities special preventive powers. Section 163 of the Bharatiya Nagarik Suraksha Sanhita replaced Section 144 of the Code of Criminal Procedure when the BNSS came into force on 1st of July 2024. It allows a district magistrate, sub-divisional magistrate, or authorized executive magistrate to issue written preventive orders when immediate prevention or speedy remedy is necessary. In practice, Section 163 may be used to restrict gatherings and processions or prohibited the carrying of weapons within a specified area. In emergency situations, an order may be issued without first hearing the people who are likely to be affected. An order issued by a magistrate ordinarily remains in force for up to 2 months. The state government may extend it for a further period within the limit prescribed under the BNSS. A person affected by the order may apply for its cancellation or modification. The authority must provide an opportunity to be heard and record reasons if the application is rejected. An arbitrary, discriminatory, or disproportionate restriction may also be challenged before a High Court under Article 226 of the Constitution. These preventive powers have repeatedly been examined by the Supreme Court. In Babulal Parathe versus State of Maharashtra 1961, the Supreme Court upheld the constitutional validity of the earlier Section 144 of the CRPC. It also stated that the power was preventive and could not be treated as unlimited or uncontrolled. In Himat Lal K. Shah versus Commissioner of Police 1973, the court recognized freedom of peaceful assembly as an essential part of democracy. It held that the state may regulate public meetings, but reasonable regulation cannot become arbitrary exclusion. In Mazdoor Kisan Shakti Sangathan versus Union of India 2018, the court considered both the rights of protesters and the rights of residents affected by continuous demonstrations near Jantar Mantar. It directed authorities to regulate protests through conditions relating to timings, participant numbers, roads, noise, weapons, and distance from sensitive institutions. In Amit Sahni versus Commissioner of Police 2020, the court recognized the right to peaceful protest. It also held that public roads and spaces could not be occupied indefinitely to the detriment of commuters and other citizens. The right to protest is not limited to Indian constitutional law. It is also protected through international human rights law. International law does not contain one separate universal treaty provisions called the right to protest. Instead, protest is protected through a combination of rights under the International Covenant on Civil and Political Rights or ICCPR to which India is a party. Under the ICCPR, Article 19 protects freedom of expression, Article 21 protects peaceful assembly, Article 22 protects freedom of association, Article 25 protects participation in public affairs. Together, these provisions recognize protest as a form of collective political expression and participation in public affairs. The United Nations Human Rights Committee's General Comment number 37 explains the meaning of peaceful assembly under Article 21 of the ICCPR. It states that peaceful assemblies may include demonstrations, marches, meetings, processions, sit-ins, vigils, and occupations of public space. International law further recognizes that the state may have a positive duty to facilitate peaceful assemblies rather than merely avoid interfering with them. These protections also create responsibilities for public authorities and provide legal remedies to affected persons. Therefore, taken together, Indian constitutional law and international human rights law recognize peaceful protest as an important form of democratic participation. At the same time, the right may be regulated through lawful, necessary, and proportionate restrictions, while public authorities remain responsible for facilitating peaceful assemblies and protecting the rights of all persons involved. Now, let us recall what we have learned through a question. With reference to the right to protest, consider the following statements. Statement 1. The right to protest in India primarily flows from Article 19, Clause 1, Subclause A, and 19, Clause 1, Subclause B of the Constitution. Statement 2. An order issued by magistrate under Section 163 of the BNSS ordinarily remains in force for a maximum of 2 months. Statement 3. Article 22 of the ICCPR specifically guarantees the right of peaceful assembly. Statement 4. In Amit Sahni versus Commissioner of Police, the Supreme Court held that public roads cannot be occupied indefinitely for protest. Which of the statements given above are correct? Option A, 1 and 2 only. Option B, 1, 2 and 3 only. Option C, 1, 2 and 4 only. Option D, 2, 3 and 4 only. Pause the video and select your answer before moving ahead. The correct answer is C, 1, 2 and 4 only. Now let us come to statement 1. Statement 1 is correct. The Constitution does not expressly mention a separate fundamental right called the right to protest. It is primarily derived from Article 19, Clause 1, Subclause A, which protects freedom of speech and expression, and Article 19, Clause 1, Subclause B, which protects the right of citizens to assemble peacefully and without arms. A protest involves both the expression of an opinion and the collective assembly of people. Therefore, these two provisions form its main constitutional basis. Now let us come to statement 2. Statement 2 is also correct. Section 163 of the BNSS allows a district magistrate, subdivisional magistrate, or another authorized executive magistrate to issue preventive order in urgent situations. An order issued by a magistrate ordinarily remains in force for a maximum of 2 months. However, this does not mean that every Section 163 order must necessarily continue for 2 months. It may be issued for a shorter period depending on the circumstances. The state government may also extend the order for a further period within the statutory limit prescribed under the BNSS. Now let us come to statement 3. Statement 3 is incorrect. Under the ICCPR, the right of peaceful assembly is protected by Article 21, not Article 22. Article 22 protects freedom of association. This includes the right to form or join organizations, unions, movements, and other groups. Both provisions may be relevant to protest, but they protect different dimensions of collective activity. Now let us come to statement 4. Statement 4 is also correct. The Amit Sahni versus Commissioner of Police case arose from the Shaheen Bagh protests. The Supreme Court recognized that citizens have a right to peaceful protest. However, it held that public roads and public spaces cannot be occupied indefinitely in a manner that causes continuing inconvenience to commuters and other members of the public. The judgment therefore emphasized the need to balance the rights of protesters with the right of other citizens using public spaces. Tell us in the comments whether you selected the correct answer before the explanation. Thank you for watching.